Hello lovely people, welcome back to my channel. Today we are going to unpack what foreign law in the Ghanaian courts means and why expert testimony matters. Before we delve into that, don't forget to like, share, comment and hit the subscription button. Now let's do it. Can a foreign marriage certificate be rejected in a Ghanaian court? Can one expert overturn an entire case? And how did a widow lose recognition in the trending Daddy Lumba case because she failed to call an expert witness? Today, let's break down how Ghanaian courts treat expert evidence, foreign marriages, and proof of foreign law and why these rules can literally decide who becomes a legal spouse. The Evidence Act of Ghana is clear. Per Section 60 of the Evidence Act, expert testimony is admissible where the court must form an opinion on matters requiring specialized knowledge such as foreign law, medical science, digital forensics, land surveying, handwriting, engineering or accounting. Judges are trained in law, not medicine, not German matrimonial law, not DNA analysis. That's why experts are needed. Section 11 of the Evidence Act provides that foreign law is a question of fact. A judge is presumed to know Ghanaian law, but not foreign law. Therefore, foreign law must be proved in court, just like any other fact. Section 40 also provides the presumption when foreign law is not proved. If no expert proves the foreign law, the court may presume the foreign law is the same as Ghanaian law. This presumption is what destroys many cases involving foreign marriages. The 1992 Constitution of Ghana also reinforced the importance of expert testimony. Article 19, 2(g) provides fair trial, which provides that parties have the right to call witnesses, including experts. Also, Article 23 provides the courts and decision-makers must act fairly. This means that courts cannot reject expert evidence without lawful reasons. Ghanaian jurisprudence firmly establishes that expert evidence is essential whenever a court must determine issues outside ordinary judicial knowledge, particularly foreign law. In ex parte Agbesi Awusu II, 1984-86, GLR 241, CA, the Court of Appeal held that foreign law is a question of fact that must be proved through qualified expert testimony, as courts cannot take judicial notice of it, nor accept opinions from unqualified persons. This principle aligns with Hilodjie v. George, 1976, GLR 429, SC, where the Supreme Court emphasized that expert opinion is admissible only where specialized knowledge is required and cannot be replaced by judicial common sense. Similarly, in Republic v. Mensah and Ors, 1979, GLR 123, the court reiterated that expert testimony, being an exception to the rule against opinion evidence, must meet standards of credibility, qualification and relevance. Later decisions, such as Republic v. Yeboah, 2003-2004, SCGLR 1, reinforced that expert evidence carries weight only when grounded in proper methodology, while Tetteh v. Hayford, 1989-92, GLR 11 confirmed that foreign documents are insufficient unless properly authenticated and contextualized through expert explanation. Collectively, these cases form the doctrinal backbone of Ghana's law on expert testimony and proof of foreign law. In the current case of Agbesi Awusu II v. Agbesi Awusu and Ors, the brief facts are that plaintiff claimed she married Daddy Lumba in Germany. She tendered a German marriage certificate. She argued she was the legal wife and entitled to perform widowhood rites. The problem is that she did not 1. Authenticate the foreign document, 2. Call an expert on German marriage law, 3. Demonstrate that her foreign marriage complied with the German Civil Code, 4. Prove recognition under Ghana's marriage ordinance, Cap 127, under Ghanaian laws. The judge cannot interpret German law without expert help. The court held that the German marriage certificate was not enough. No expert was called to prove 1. Validity of the German marriage, 2. Registration requirements, and 3. Recognition under Ghanaian law. Therefore, the court presumed German law is equal to Ghanaian law under Section 40. Under Ghanaian law, the marriage was not valid. the customary wife was declared the surviving spouse. In Ghana, you cannot prove a foreign marriage without expert evidence. Not even if your certificate looks legitimate. Not even if the marriage was real. It is trite that expert evidence is the backbone of cases involving foreign law, science, medicine or technology. Daddy Lumba case shows that even a genuine foreign marriage can collapse in court if it is not proved properly. So, it is important to note that, whether you marry abroad, handle estates, or litigate cross-border disputes, remember that foreign law is fact and facts must be proved by experts. See you in my next video. Bye.